Yeah, warm welcome to our Big Tech Regulation for Beginners. I'm happy that we have a full room today. We were afraid that not many people would be interested, but that shows how relevant this debate is and the necessity that many people see, despite this being about the law, about enforcing laws from authorities whose names you probably know, but part of you don't really know what they're actually doing in detail. That's what we want to talk about in this hour, because we're at the turning point with the Digital Service Act, the Digital Market Act, and GDPR. The European Union has created rules and regulations for platforms, but how strong they are, how well it works to enforce them, and how it is enforced, we want to talk about with three heads of authorities who also represent all the other authorities who are kind of connected to this whole topic. It would be too much for this hour to go into all the details. That's why we have only three sitting here. Professor Louisa Specht-Riemenschneider isn't all that new. She is the Federal Commissioner for Data Protection and Freedom of Information. And she is in charge of enforcing GDPR or not. We're going to talk about that. A warm applause for Louisa. In the middle, we see Andreas Mundt, the president of the Federal Cartel Office. He might be the most unknown authority representative of all the three, but they play a central part in enforcing the Digital Markets Act. This isn't a put down. I've always wanted to know more about the laws around cartels. Today is your chance. So, an applause for Andreas Mundt. And to my right, from your point of view, is Klaus Müller, the president of the Federal Network Agency. And, well, up until now, Germany's digital service coordinator, or do you already have a replacement found? You can talk about that. And he is in charge of the implementation of the Digital Service Act in Germany. A warm applause for him. So let's start. Let's talk about some terms. I was happy to notice some people met for the first time here. They're all living in Bonn. It's not that far away, and Bonn is the capital of regulations. I'm happy to say that, being from Bonn myself. So let's start with Klaus Müller. The Federal Network Agency coordinates Germany's Digital Service Act. What does that mean? What is the Federal Network Agency, and what is the Digital Service Coordinator? That's a difficult question, but quick to answer. Basically, we're in charge of everything which are markets bound to the net. Normally, I will talk to you about electricity, about gas, infrastructure, fiber optic cables, and if you want to annoy me, postal services. But that's not what I'm invited here for today. Since last year, platforms, digital platforms, have been added to this list. And just as capitalism doesn't just work on network-bound markets, it doesn't just work in platforms. And the Digital Services Act says, depending on the size of the platform or search engine, it's territory of the European Union. So everything which is fun is Brussels' job, Facebook, TikTok, Google, Meta, Shein, Temo, and so on, and all the rest, and has their head office in Germany, is a Federal Network Agency, and then there's also some coordination tasks, also calculation of risks, so we're going to talk about that in the next hour. Louisa, many can't know GDPR, but I think fewer people understand how enforcement works in Germany. How much do you have to do with that as the Federal Commissioner for Data Protection? That needs a lot more than 140 characters. Enforcing rights in Germany and Europe is somewhat complex. We have 18 authorities for data protection in Germany. There is one in every country. Bavaria has 2, and one in federal level, that's mine. And in the European Union, every state has 1 or 2, and together we are trying to enforce GDPR with coordination mechanisms, etc. Tell me if I should go into more detail, but maybe that's enough for the moment. I think complexity has been made clear. Mr. Mundt, Digital Market Act is enforced by the EU, but you were spearheading the enforcement of competition against big tech. How exactly are you working together with the EU Commission, and what is your job? Well, dear Mr. Beckedahl, actually I was here 4 years ago and I filled the room by myself. I am not that sure that everybody in this room does not know the Federal Cartel Office. So the Federal Cartel Office and me, we are also in charge of Apple, Amazon, Apple, Facebook, the big ones, big guys. And in the past, we sued them several times. A federal cartel agency is playing in the top tier when it comes to enforcement of laws worldwide. We can forbid fusions, mergers on the digital realm, but we are actually in charge of surveillance of oversight for companies which don't have enough oversight. We have a long history in the digital markets. Our first process was against Booking. Both had the same clause in their contracts, which said companies that offer products with us cannot offer it cheaper anywhere else. Sounds great for the consumer. Come to me, it's not going to get any cheaper, but in terms of competition, it's a catastrophe because other platforms have such a hard time because of that. That was one of our first cases that we did. It's 14 years ago. We forbid that for all of Europe, and in the US, Amazon is going to be subject to that as well, finally. So we have a long history, and we have fresh, new cases again, just like Klaus, together with the European Commission, who applies the Digital Markets Act, and there is a a close collaboration, and we're sharing the cases. Let's talk about the cases in detail to make this a bit more practical. Which actual cases are you working on with how many people? How bad that you're putting such a downer first. I'm going to start with the second part of your question. I think everybody knows the last government was not able to complete their work. So there is no budget for 2025. And that was the start of the Digital Service Coordinator. So there is effort anchored in law saying the Parliament states how many people are supposedly needed, and we're working with a quarter of this number. Imagine running Republika with a quarter of the people, then you know how we're feeling right now. What are we doing despite this? We're in charge of dealing with topics like the integrity of elections. So the Parliament played a role, and a lot of criticism that probably everybody has on the activities of certain platforms. We did not have a major interference in our elections. How did you verify that? We all were part of it. Yeah, hopefully you voted. Because we were together with all the other authorities and institutions, we asked the platforms for some friendly conversations together with the EU Commission and asked them to show us in a stress test, how does it work if somebody would have stopped the social media account of Olaf Scholz, Habeck, or someone else. That would have been influencing the elections in the middle of a campaign. Or if we would have seen a major breaking of the law on the platforms. We did all those scenarios with them. None of that actually happened. That was one of the things we did, or one of the topics we dealt with. Now we have other topics. Protection of youth and media, and the big cases against X, TikTok, Temu, and Chi. We're going to talk about that later. Louisa, your topic was in the media yesterday, everywhere. Resistance against Facebook and Meta. How did it come about that Facebook or Meta is even allowed to take all our data and consolidate it without asking us for permission first? Well, I have to breathe deeply first and find the inner calm and have to say I am enraged. It's unbelievable. But there is a long process leading up to this. I'm personally of the opinion that bringing together the data and training the artificial intelligence through Meta is dubious in a legal sense, to say the least. But your question is justified. How did that even happen? Meta started a case a while ago against the European authorities. I think it might look like we're all dealing with everything, but Meta is the responsibility of the Irish Data Protection Agency because their main offices their headquarters are in Ireland. As I said, everything which is fun is not here. So we in Germany are not the first line of defense against Meta, but we work together in a case with those authorities. Meta showed this case to the Irish authorities. They forbid certain things that were supposed to happen there. Then certain amendments were made. Measurements for mitigation happened. What is that? I cannot talk in too much legalese here, but it's supposed to mitigate risk for people affected. And then Ireland did the following. There is basically you're not allowed to process data unless the law allows you. And one of the opportunities to do that is asking you, Markus, do you allow me to give you to use your data to train the artificial intelligence? Then it's allowed. But on top of that, there are other things that make it possible. And the other thing is justified interest. And based on justified interest, Meta does their AI training. And you justify that by the fact that there is the option to opt out. Why do I think this might be a mistake? Why I don't think it applies to do this with such a generalization. We all know if you want to build an AI, there has to be some basis in the law, but we're not having the discussion which AI is allowed to use which data. There is a difference if I build one to heal people or if I just want to earn money. So I'm pleading all of you, let's discuss this. It's time. And then we need, in an area which is so relevant to basic law, I hope we all screamed when it came out that Meta wants to train their AI without permission. So we need a decision by the lawmakers which are the circumstances in which it's allowed and which are the circumstances where not. And right now, it's rather vague. So each authority can interpret this differently. So Ireland has given it a go for data which already exist and future data. I believe for historical data that is already in the system, I would have said there has to be an explicit opt-in, and you cannot do this by vested interest. But one of the main points that you have to emphasize, if you do this via an opt-out solution, then having to spend half an hour finding the button to opt out, that really does not work. It has to be visible on the main page directly. So I think, generally speaking, it's not possible to judge it that way, but the Irish authorities decided this way. They did not say it is allowed to train AI, but we're going to look if the measurements for mitigation actually work for the data that it's already in.
DSG.
So do you think that's kind of a birth defect that it gave, that the Irish Data Protection Authority is now doing your work? Is that the birth defect of the GDPR? Well, to be clear, my work, I am primarily responsible for work of federal agencies related to post and telecommunications. So we basically have a division of labor between these different agencies. The legislator essentially decided to base this responsibility based on the principle of where the company is based. And obviously that's something that can be discussed controversially, but I also think I need to defend my colleagues in Ireland. They imposed huge fines on TikTok. They imposed large fines on Meta. So there was definitely significant fines that were put on various institutions, various companies. But I think it needs to be possible for example, the German agency to say I disagree. But there's in the end there's a European process to find a solution, and my voice is just one of many. Mr. Mundt, you and the Federal Cartel Office won a lawsuit against Google, which bans the unification of data across different markets. So why were you not able to intervene in this case? Oh, so that it wasn't Google, it was Facebook? And it's been a while. I mean, to begin with, we as competition lawyers, we are in a pretty happy situation compared to the two of you, because we can essentially take up any case that happens in Germany. So if Google or Alphabet or Meta don't follow the rules in Germany, then the Federal Cartel Office can intervene. And we have a very nice principle. If it affects other countries, then we collaborate. Or the European Commission can be responsible. We all apply European law. And so it's not easily graspable question of what you are responsible for, but essentially if it happens in your country, you can work on it. So if you want to understand the whole Meta thing, you need to look at Facebook in the year 2016. I mean, that's basically the Stone Ages seen from now. That's when this case started, and it was about the question, just as Ms. Specht-Riemenschneider illustrated just now. At the time, the question was, can Facebook make the usage of its platform dependent on us sharing all of our data without any limitations with Facebook? And if we say we don't want to share that data, is it allowable for Facebook to just say, no, then you can't use our service? And we basically said that's a competition law case, because all of this market power that Facebook has derives from all of this data. This data needs to be acquired legally. And if Facebook essentially acts in a way that, in our opinion, violates the GDPR, then that's not a legal acquisition of the data. And then we can use the competition law as a basis for banning that, because the data is such a strong and important source of market power for Facebook. As federal cartel agency, we don't, a cartel office, we don't apply data protection law. But the way we've always explained it, data protection rules, to the extent that they have a relationship to market power, we can look at, we can take that into account when we implement one of these cases. When we did that back in the day, we were described as hipster antitrust. Today, this principle is written into the Digital Markets Act, and it's also written into German competition law. This case, I mean, I also think it's very interesting. I'm one of those people who remembered yesterday morning that there's a deadline with Facebook. Because of my post, right? Well, yeah, also. And I wanted to opt out real quick. Real quick. I spent half an hour digging through Facebook and finding the part of the settings where I can opt out. but it took me half an hour, and I was like, oh, I mean, I'm someone who knows a bit about this. We spent a lot of time talking to Facebook and about how to design these settings in a way that is that complies with competition law. So I don't even want to imagine how complicated this is for someone who does not work with this, because we all have better things to do than spending a whole day figuring out how to opt out of some kind of Facebook data usage. So I managed to find it in the end, but it took half an hour. So it really would be quite nice if there was a button that just says, opt out of everything without any further explanations, where you have to click through for ages. So if I can look at that from like a competition law perspective, I want to say neither. I want to say neither yes or no. I never talk about hypothetical cases. Yeah, I mean that was quite a thing. So how should I imagine your work in practice? So for example, Google or Meta does something that upsets people. Where do you get started, or where does the EU come in with the Digital Markets Act? So the Digital Markets Act essentially sets out certain types of behaviors that are based on cases that we've brought in Brussels, Paris, Berlin. And if a case falls clearly under the Digital Markets Act, then we cannot do anything at the national level. Then the European Commission is responsible. But there are many areas that do not fall under the DMA. And in those cases, the cartel office can take up a case. For example, if a certain service is not designated, such as AI, which is not something you cannot designate under the DMA, then the federal cartel office can do something about that case. Or if certain types of behaviors are not described in the DMA, then we can also take care of that. Another example is the process, the whole suit against Apple, which is still ongoing. For example, if you download an app from Apple's App Store, you get a very nice friendly notice that says this app tracks you, and there's a nice question of like, oh, do you agree with that? And then you say yes, because the question is being asked so nicely. But if it's not an app by Apple, then you're not being asked once, but you're asked 4 times, and the questions are worded very differently, and worded something like, do you know what's happening here? Are you aware that this is potentially threatening or dangerous? So basically, in other words, there's a kind of steering here based on whether you're dealing with an Apple app or a non-Apple app. And as I said, this is like an ongoing case, but we essentially said this is a question of market power. Apple can only do this because it already has enormous power in the market, and so I'm very careful about this because it's a pending case, but we are in the middle of kind of trying to influence that in a good direction. So that's not a DMA case, but that's a concrete example of how we can also take up these cases in Bonn. So I just want to get back to you real quick. So this the whole tracking thing. Why is it legal? When I say like 4 times, like, yes, you can track me, that there are 800 different companies in the background that find out about my location. Well, it's legal to a certain degree, so it's a huge problem. And that's also something where I really think it's a birth defect of the GDPR. The GDPR does the following. It says the user can agree to their data being processed, and if they do, it is legal. And for them to be able to agree, it is required, like they need to essentially have the information to provide informed consent, so that for the user can inform themselves. It's not about the user being informed. So it's not about the user. It's not about the user actually understanding the information that they receive, but it states it has a lot of obligations to provide information. And we all know, I mean, I would love to ask, like, how many of you read data protection declarations? How many of you read, like, the general terms and conditions? At least 4, here, first row. Like, very justifiably, many people do not read these data protection declarations because we all know in consumer rights law since the 1960s, the more information you are presented with, the less you actually digest, because we say, oh, I can't read all of that, and regardless of whether I read that or not, and that's why we essentially get back to competition law. I need to use this service regardless, because this this process of agreement or consent does essentially not really care about that to some extent. Often it ends up leaving the users uninformed, and I clearly tell this to legislators as well, and the people who write these laws. The legislator knows this, has known this since the 60s, and that's why this process for consent are often not written in a way that ensures that the user actually understands them, but to simply fulfill these obligations to provide information. I'm not saying that all of this tracking, especially when it's like 800 in the background, and we just had a legal decision that said that it's actually not necessarily justified. So I'm not saying that's justified, but basically the core problem here is that often these consent agreements are so unclear. But so there's really an important question, like what would the user actually understand if they read that? So I don't want to say that I'm not responsible here or anything, but I really think, I've been saying this for 10 years, dear legislator, please fix this, please help the users, because you're really leaving them on their own there, and So I'm interested in your work. So Klaus, you already said you do kind of planning games with the organizations. I'm sure that's good and that makes sense. But we're essentially talking about companies where lots of data are processed on servers, where the mechanisms might not be super transparent. How do you control that? How do you practice oversight? Do you go to the server room and do you get access? No, and I don't even know if that would be helpful. So I think planning simulation games sounds like a bit cute, but these were really stress tests. But now, for example, all digital service coordinators are doing these based on a set principle to ensure that in the case of an actual threat, we can ensure that the search engines, platforms can react in the way they have to react. So now the EU Commission has said everything that's fun happens in Brussels, but access to a server room, that's not something that would really help us. The Digital Services Act does not define how individual cases are to be treated. For example, if it says on X that Markus Beckedahl is an idiot, that's bad, but that's not something that the Digital Services Act is interested in. The DSA is interested in whether there's a systemic risk, and that is both a blessing and a curse. Because what's a systemic risk? And probably, so I'm not a lawyer, but I assume that we will need high court decisions for this. And the European Commission probably already anticipates that. And so a lot of these cases, I assume, are being prepared very intensely and with a lot of detail, because these companies will obviously defend themselves. TikTok, Meta will defend themselves against these cases. And so these court cases, especially, and this investigative procedure, especially when it comes to access to servers, that is being prepared very, very carefully, because in the end, it is a legal tool and they need to win in court. Second, the thing that I find fascinating about the DSA is that not only government agencies need to have the competencies, but civil society and researchers are supposed to have certain oversight competencies as well. And so, for example, there are things like trusted flaggers are supposed to have the chance to get a priority when they raise these issues to these platforms. Mediators are supposed to have an opportunity to mediate certain conflicts. Access to information for researchers is a really important part of the DSA. So it essentially enables third parties to get some insight into search engines and platforms. How long is it going to take until we have these high court decisions? Because sometimes it feels like the platforms are essentially looking at this and are like, oh, well, I have 5 years, I can set the world on fire, and then don't care what happens after that. Yeah, and so I'm afraid you basically named a time frame there that might be too short, because we'll have to go through several levels of the digital system, and part of me might be very unhappy with that, and we often get I get the feeling from various organizations, NGOs, citizens, people have this feeling that the house is already on fire, that there's imminent danger there might be elections, there are imminent e-commerce questions. But that's not how the DSA is designed. It's intended to be a marathon rather than a sprint.
Mr. Mundt, how are you dealing with this as the Federal Cartel Agency? Are you getting data sent by email, or do you get sticks, or how do you analyze it? There are cases where you don't even need that much data. Sometimes you need a lot of data. Facebook, at one point, gave that much data to the European Commission in one case that it wasn't physically possible to save that data, not even analyze it. That's sometimes a strategy. We often react to complaints. We are, in the big cases, we're trying to make companies change their behavior, and we often do a market test first. Quite often somebody is affected by that bad behavior, suffering from that, and we're giving that out to the market, ask if that's a good possibility. The other option is to work with trustees who accompany the implementation of that case. And we added a lot of resources in our authority. We have a lot of data scientists now. We used just to be lawyers and economists. Now we have quite a few data scientists, and that's how we try to enforce those cases. Enforcement is hard, especially with the courts. I'm going to give you one vivid example from the Facebook case. It went to a higher court. We lost it. Then we went one court higher. We won. Then we went back to the lower court, lost again, back to another court. We were about to win. Then they took it back. And then we were back to the first court. And then the highest court said, oh, so difficult. You have to go to the European court. Then it was in Brussels. We won that. And then the case went back to the very first court in Düsseldorf. 5 years had passed, and there wasn't one single decision about the case. All of those were preliminary decisions. I don't want to rant. That's just how rule of law works. But they say we authorities have to become quicker. Just saying, our case took 2016 to 2019. The courts took 5 years, and there is no decision yet. In the end, we settled the case with Facebook. Everything you see on Facebook nowadays, the whole dashboard, how you agree, what you're getting declared, all of that has been cleared with the Federal Cartel Office. And today I realized we might not have done enough, but that's a different story. But yeah, that's how we try to enforce those cases. But you're right. The case, the substance, the data, that's one thing. But in the end, the real actual enforcement, that the companies actually do what has been decided, that's the second thing. And you always have to think those two things together. Louisa, you as the GDPR commissioner, you can go to the server room and check, no? Well, I have a lot of authority, yes, but I have to say I'm not happy. It's the 100th panel where justifiably they say authorities are too slow, lawmakers are too slow, and in the end, I am a lawyer. If nobody complies to the law, then law loses its function. That's what we need to talk about. And then we also have to think, how do we get out of this situation? We as authorities can only play a little part in that, but I can explain how I try to deal with this. I am not originally from an authority. I was a lawyer. I worked at university. I've always worked interdisciplinary, seen a lot from different countries. Other countries are actually doing things better, also in trying to stay on top of all of this. I have three functions. I need to inform, I need to consult, and I need to oversee. In the end, that means doling out some punishments if something didn't work. But I can also go anywhere, look at things and say, hey, the way how this works is bad, and that's why we're going to change it. I can set legal measures. I can forbid data being processed in my area where I have the authority. That is the function of oversight. In 99% of the cases, that's too late. It is possible to make some measures preliminarily, but that's usually too late. So the question is, how can we manage it that companies and the ones that process the data act in accordance with the law? That's the goal of any oversight authority, that people act according to the law. And I think that only works that if we empower people who want to act in accordance to GDPR, so empower everybody who wants to comply with GDPR. We can try, for instance, to use new technology. You can also say something about that later. Try this in real time with developers and users and check which are the GDPR, the data protection challenges and how to solve them. Not just say, that doesn't work, that doesn't work, that doesn't work, but rather say, people, GDPR does not state at any point that data is not allowed to be processed. That's nowhere. It says GDPR makes the rules by which data may be processed. And that means some data processing which endangers the rights of the people affected a lot might be forbidden. But on most cases, process data to heal people or protect them, then there's just guidelines. How do you do it? Anonymize the data, erase it at some point. That's how you do it, so nothing goes wrong. And show those options on how to solve the problem. Not just say, that's not work, that doesn't work, that doesn't work, but work together and make it work. That's one way how we can take a step in the right direction in a real-time environment. And one of the words that is said quite often, some might say that's just a word she made up. I think it could work. It means we have one use case that you can look at that represents a lot of use cases with questions that nobody asked beforehand that we answer. And the answer can then be abstracted, communicated with the public, so it can be imitated. First instrument. The second instrument that I find quite important and that is used abroad is called strategic foresight, to check what is coming towards us. That Meta is going to use data to train their AI. Honestly, it wasn't clear in 2012 when I entered Facebook. By the way, I erased my account, deleted my account. But that was 4, 3, 5, 6 years ago. We could have foreseen this. We should have positioned ourselves before the trouble happens. We need to be able to do strategic foresight a lot more so we can provide a framework that everybody can comply with. Well, we're dealing with companies here. It's mainly about regulating big tech who do things like that, foresight, who also can afford the best lawyers, who can plan the laws, the enforcement, with courts being slow and slow and slow, and who already make a budget for the reactions. No, move fast, break things, strategies, just have some money saved to pay the fines and just see how far they can get. How do we deal with this? Or how do you deal with this? What would you wish for to have as tools against that? Are we in a good position? Mr. Mundt. Well, in our area, the lawmaker reacted with the Digital Market Act. The Digital Markets Act has been in effect for 2 years, and as Laura Riemenschneider showed how difficult it is to do foresight. You have to think, DMA is in practice for 2 years, and it does not contain AI, even though it's a big problem of market power. I can just show you, what do I need for AI? I need infrastructure. That's the cloud. Who has that? 3 companies, Amazon, Google, Azure, Microsoft. And what else do I need? Data. Who has data? Well, just a little hint. Meta has data about 3.2 billion users. And since this morning, if they didn't opt out, their model is going to be trained with this. That's an unimaginable number. But these are developments, I have to say, who could have foreseen that 2, 3, 4, 5 years ago? Maybe the companies in their inner circle, but absolutely not the authorities, the government, which is not part of this inner circle. Yeah, that's the problem. I still think we have good tools by now. Digital Market Act in Brussels works with exactly those big cases, regulates those companies, tells them how they have to behave. But the burden of proof, which is something we learned from those long cases, the burden of proof that the companies act accordingly is with the companies, not with authorities. There are high fines if they're not behaving correctly. So there's a lot of angles there which we can use to make those cases quicker. But what remains, and none of us can make that go away by magic, the Federal Cartel Agency, everybody in my agency, 450 people, you can be sure in a large case which affects a big company, there are lawyers, institutions, consultancies, data scientists. I'm not going to say the same amount, but it feels like it, are against you. And then you're sitting in a room with this absolute overpowering competency. We cannot put our data into some sort of cloud. You cannot put the secrets of the German industry into the Amazon cloud. I just heard another talk about digitalization of the state. We can't even do that up until this point. And then on the other side of the table, there are 3 hyperscalers who dominate worldwide markets with their cloud. I cannot overemphasize this difference in scale. You have to be quite resilient as an authority. You have to attack resolutely. I think we're fending quite well. The European Commission just is working on the payout concept of Meta, is working on the steering commissions of Apple, is regulating Google. We just closed 2 cases against Google on maps and infotainment. So I'll have to say, if you take into account this imbalance, the state is doing a lot thanks to the enthusiasm, I have to say, in those authorities. I am impressed. For the moment, I cannot say more. And what we haven't talked about yet, in the US there's also still cases. And if I'm looking at what happens on the front of AI, it's quite interesting. We're going to get to that. So what you want is a sovereign cloud and then you're happy? Really? Did I express myself so badly? Louisa, what would you wish for? What has to change? Nah. Well, a few weeks ago, I was in Britain. A person that I admire very much told me, Lisa, please always stay impatient. I wish for more impatience. Honestly, we're at this inflection point. And this point is, I am not content where we are standing. I am not content that a lot of laws are broken on the web, that we cannot enforce our laws. We have big cases, yes. The authorities do a great job, I have to say this at this point, but we're in a situation out of which we can honestly not really get out if we don't change things. And I don't have the silver bullet, but we have to go into a direction where we're not saying, well, companies have such an advantage on us, we cannot defend much. We have to get better. We have to match their powers, and then we can be on equal terms with them and enforce our laws. Well, strategic foresight, what can we know? That's a whole discipline of science. There is a lot already, but we need to find a dialogue. When we foresee things that are developing, if I just look at one specific domain, I think it's only possible to foresee technological developments if you network between bubbles, if you look at different topics, different structures, and then check what might that lead to and what challenges should we be aware of. You can't resolve that from one day to the other. It's a bit dissatisfactory, but if we want to get out, that's the only opportunity. So you mainly want foresight, a cloud foresight. What do you want? Well, if I could change something, I need to prove risks for the system. How do I prove risks? If I document a large number of individual processes. So I'm playing the ball back to you, all of you, for platforms, search engine, e-commerce, or liberal democracy, the social media area. If there are problems there, we need to know about this. We could mean the media authority, the criminal agencies, any institution. We need to know about it.
We also need to get better at that ourselves. I mean, that was your original question. There's definitely a need for resources, but it's very essentially across Europe we need reports, tips to create these justiciable cases based on that. We need this empirical information. So, okay, to ask very differently. Here are 3 regulatory agencies. You already mentioned the state media agencies. You mentioned there are 17 state-level agencies that work with you for data protection. Wouldn't it make sense to put all of that into a single agency to essentially create a digital oversight agency where the best people work so they can really work at eye level with the companies? Yeah, let's start with you, maybe. So at least for I don't respond for the entire for all digital matters, but for my area. But so the coalition agreement for the new government actually says that there's supposed to be a centralization of oversight of the economy on digital matters in my agency. And personally, I would be in favor of, at the very least, centralizing oversight for entities, companies that are active across different regions, because that would at least centralize some of these oversight processes, would probably save resources and personnel. It would help with essentially putting out guidance for interpreting certain terms that might be unclear, but an individual could still complain to their local or regional agency because regional economy would not be affected by such a centralization. As a Commissioner for Data Protection, I would be available for that. Just to say, regarding a complete holistic digital agency, I think that would be so big that all the coordination, even just within this organization, the bureaucratic processes, would essentially grow to a monstrous size. So I think you need to find a balance between ensuring having things like coherent and centralized in a place, and just not having too much bureaucracy. Yeah, I also think like a single huge agency would be too much. Like, it is important that relevant knowledge is centralized in the responsible agencies. But one thing I find, so for us, this very close cooperation with the EU, essentially our working language practically is English, right? Even if we write things in German on paper. If you want to work in this area with data scientists, then our colleagues don't just sit in Bonn, they also sit in Brussels and Paris. I almost said London, but well, not since Brexit. They sit in Madrid. That's not a single agency, but it's difficult to imagine how it could be more networked already. So from my office, I can see for every single office in Europe which case are they working on, including digital matters, like where's this case at, who are they working with, who would I have to contact. Just as an aside, that also makes working at the Federal Cartel Office a very interesting place to work. Just to put it out there, especially considering that there are a lot of young people here who might be interested in that. And so all of this is in order to enable us to deal with these companies, with our colleagues like across Europe, across areas. So that's there's an enormous bandwidth. And if I included Louisa and Klaus in that, integrated them into the same agency, that would be so large, too big to still steer that in any particular direction. So networking, connecting within any given areas, absolutely yes, but I don't think it makes sense to move all of these areas together and merge all of them. Whether size really matters, I'm not so sure about that. So we are 3,300 people, Andreas, but in our pluralistic society, there are different kinds of interests, and in English, people like to talk about checks and balances. So I think Germany really needs a strong data protection oversight, but that is not in itself the same as a strong enforcer of competition law with a perspective focused on competition law, and that is not inherently the same as our interest as a regulator to create networks or enforce fair rules of the game on digital platforms. I don't think that has to be the same for societal debates, for existing together and next to each other. I think it's important that all of these three legitimate interests are well based in domain area knowledge and connected with existing agencies. And so the previous government already started working on that and essentially said, oh, we want to create something like a digital agency within the Federal Network Agency. And the last government didn't just give us competency to take care of the platform stuff, but also created prerequisites for the Digital Platforms Act and the AI Act, and essentially began moving core responsibilities in these areas in one place. Where the next government is moving, we will see, but at least some of it has been prepared. Some foundational work has been done here. Okay, we won't get to the AI Act, but I have one question about the European Commission, because it is responsible for both the implementation and for trade conflicts or debates about tariffs with the Trump government. Does that make sense, or wouldn't it have been better to have a more independent digital agency? I mean, that's criticism that's been raised previously repeatedly. If we existed in a perfect world and would design Europe from the ground up, then I think every single lawyer would agree with you, but we just don't live in this perfect world. As Andreas described, we basically have a board meeting every month of the Digital Services Act. The Commission has representatives there and is running these meetings, but at least for the last year. I can tell you that at no moment was there a single voice from the Commission that would say, that said something like, oh, let's not sue sue X or go up against Meta because of economic interests. Well, but the tariffs have only existed for a month. Well, I mean, the Trump thing has been out there since November. And so, I mean, I'm just telling you, at least so far, that has not been the case. And there are 27 digital service coordinators, and they're different for sure. But I don't think that they would let that happen. But so for now, I'm reassured. But ask me again in a year. At least for now, I think it's definitely interesting because the Commission has already levied significant fines based on the DMA on some of these companies. And I mean, the U.S. government has a certain tendency and to claim that these are tariffs on our companies. But I definitely have to say, at least in the last few weeks, the Commission has also imposed further fines. And during that time, they were already under the impression and aware of the so-called Liberation Day, and they still impose these fines. And I can only say, based on my conversations with Teresa Rivera and others at the Commission, I do not have the impression whatsoever that they are being influenced by that. But of course, we have to keep an eye on how this changes. I've seen WTO negotiations where different parts of porks were being traded. Trade is people in trade are known for having razors on their elbows. We really have to just keep an eye on that. But I absolutely agree with Klaus. I see no concerns whatsoever, and I don't see any way in which the Commission has given on that. I mean, do you want to say no? I mean, I'd rather answer your next question. Okay, so very, very last question. We're at Republica. We talked for 3 days about how a better digital world is possible. We need to use decentralized digital platforms. Klaus, at the Network Agency, do you use Mastodon or Fediverse services? Some of them, yes. But we're also still active on the classic platforms. But you, Klaus, well, yeah. So we are already on the classic platforms, including Republica. Let's see what's up next. But you're not on Mastodon yet. No, not yet. I mean, today could be the chance, right? Well, yes, I've heard it. Well, yeah, of course, we are. Yeah. So that was the panel regulation for beginners. I hope that gave you some insight into how complex all of this is. We have entities that want cloud, a bit more personnel, a bit more foresight. So yeah, maybe we can have some hope that big tech's dominance will be diminished a little bit in the future.